Pension law is exciting. I like to say it's socially credible to admit to being a pension lawyer now at dinner parties. Sadly, I still don't get invited to dinner parties, but it is exciting. It's a very technical area because of the different relationships, the trustee, the members, the employer, this sort of classic triangular relationship, but with different aspects that come through. The whole funding issue on pension schemes, they're very important for the members. They're a way of securing benefits payable into the future. They're very important for the employers, the cost and expense and wanting to provide the benefits. And then the trustees in the middle, you see a lot of regulation, a lot of statute, and that all combines into quite a difficult area. Not much written on it. I'm trying to single-handedly solve that, but not as much as it perhaps deserves. I think people are too busy doing it to write about it. It is part of the problem, but it's always an exciting area to be dealing with those important areas. There are a number of cases coming out. Pensions is such an exciting area in that sense that there's a lot of money at stake and a lot can turn on particular issues. So there have been several cases this year, 2014, a case involving how amendment powers are exercised, called gleeds, whether or not a deed is needed or not needed. That's probably going on appeal, but that was a key case on amendment. And a case on powers of employers, which is a chapter in the book, the IBM decision about whether an employer has what restrictions there are on an employer exercising powers under a pension scheme, the implied mutual duty of trust and confidence, acting in good faith, and slightly unusually the judge held that the employer in that case had broken that duty, so we're waiting a second round about what the consequences of that are. But whether that's a one-off or a general one, it's certainly given rise to a lot of work for pension lawyers. Pension schemes are always going to be there and always going to be interesting. I always tell my clients that if your lawyer says this is interesting, that's probably a bad sign. You really want your lawyer to say, no, it's very boring. But it's always going to be interesting. There's going to be ebbs and flows on defined benefit and defined contribution. We're already seeing the government introducing legislation to deal more with defined contribution. We have auto-enrolment going forward. But the roles and duties of trustees and employers in defined benefit schemes are still going to be there. I think if I venture a prediction, we're in an era of deficits at the moment, people dealing with those. I perhaps hope that we might move into an era of surpluses in the future as interest rates go up and things like that. And they pose their own issues and their own difficulties. There is a chapter in the book on surpluses, but I'm sort of hopeful that that will be the issue that arises in 5-10 years' time.